right. Hello, everyone. Hey, Katya, how are you?
Hi, Numa. I'm good, thank you. And you?
So far, so good. Good to see you. And thank you for everyone for attending this webinar. If you have any problem with the audio or whatever technical problem, feel free to put it on the discussion section. And as I typed on the discussion section, if you have any question, going around all along the webinar, feel free to just type it down. And at the end of the webinar, we will, of course, answer them. I've got a few slides. It's always convenient to share.
Yes, indeed.
Indeed, if I find them, indeed.
You will find them.
Okay. All right. It looks like it. All right, once again, thank you so much for attending this webinar today. It's a real pleasure with Katya to have you for this very first time. We are doing a webinar together on this very, very sensitive topic, but crucial right now, given the circumstances. Right before diving into this case, just a few disclaimer. We are lawyers and attorneys, so we love disclaimer. That's kind of a bread and butter of the profession, but also quite important, especially in this type of context. All the information that we presented to you, of course, is regarding the best effort that we have to find this information. Is highly fragmented right now, given the short period of time. It's also indeed fluctuating a lot. Like for at least for the space sector, we had like fresh news arriving yesterday. That's the case for all the other sector impacted by the sanction. But globally, the sanction regime is highly fluctuating, and that can be quite dramatic in a months or even week period of time. So be clear on this. Also, this is not legal advice that we are providing to you. It's more of an information. And if you have a regulation that are impacting specifically your activity, you need to have a strict analysis done on a case-by-case basis only, because there is so many exemptions, so many cases, and we will see that on the slide. So many dialogue with administration that it's really a case-by-case analysis. And indeed, because we are lawyers, so most of what we do are contract, and each contract is different. So you need to have a very specific focus when dealing with this type of regulations. Katya, if you need to add anything, feel free to.
Sure. That's very well said, Numa. And
thank you.
Also, it's very fact specific. So each case has very specific facts. So we will need to assess each fact of your situation and then see what is the scenario that is applicable to your case. So yeah, that's something to bear in mind too.
All right, great. Then this is said. So just a few word of introduction. Katya, if you want to introduce yourself, please, you have the floor.
Yes, sure. Thank you very much, Numa, and welcome everyone. I'm a qualified lawyer in Luxembourg, and I have over 10 years of experience now in all type of commercial transactions and financial regulatory. And I launched my own law firm that is specializing in corporate financial regulatory issues. And I'm also a qualified solicitor in the UK. So yeah, I will be very glad to present you an overview of the sanctions regime and answer any questions you may have.
Awesome. And please, if you need to contact Katya, of course, you can type an email, whatever, but you can also scan the QR code on the screen and you will directly access to a LinkedIn profile so you can reach her directly.
Yes.
And as for me, my name is Numa Isna. I'm an attorney at law. I'm based in Paris, and I created a firm. The name is Space Avocat, and I'm specializing in space activities and mostly tech, also dual use. We will see what it is in a few moments, and also doing work quite globally for the space industry. Jumping on it, we thought it was quite interesting and relevant for this presentation to have a kind of a 360 vision of what is a sanction, because everybody's talking about sanction. We see that on the press all over the world, but what is actually the regime? How does that work? Who are the stakeholders of this type of very specific legal regime? Katya, the floor is yours if you want to start the presentation.
Yes, thank you very much, Numa. I know we have a very diverse audience right now, so not only composed of lawyers, So I thought it will be very interesting to kind of just explain you the very generalities of how a sanctions regime work. In front of your screen, you can see there are very, very many regulations at the EU level that have been imposed. The original one being dated as of 2014, and there have been a long list of amendments that have been made since then and have been increased since 2022. So on your screen, you can see the two major regulations that are currently applicable to our case. One is in relation to financial industry, trade, space, etc. So it's more like sector specific. And the other one, the second one, is in relation to the freezing of assets and making available funds to a certain type of individuals that are precisely listed in the regulations. So today we're focusing on the generalities of how this sanctions regime work, and I will give you a very brief comparison between three jurisdictions: the EU, US, and UK. A small disclaimer here, because I'm also a lawyer. I'm not qualified in the US. I do have a partner. I know a partner who has a law firm working in the US, so in California more precisely. So if you have any specific question in relation to the US, please reach out to me and we will arrange something. So in consideration of who can impose, who has the power to issue and enforce the sanctions. So at the EU level, it's basically the Council of the EU who has the power, as laid down by the treaty, to impose any new sanctions. And then it comes to each member state to implement and to enforce those sanctions. And of course, the EU Commission monitors the applications that are the application by the member states of the sanctions issues. In the US, since it's a federal regime, so the competence is either within the US Congress that regulates by way of statutes, or the executive orders that are directly issued by the White House. And the entity that is in charge of the administration and enforcement of the sanctions is called OFAC. So it's Office of Foreign Assets Control of the US Department and of the Treasury. And that also codified certain regulations that are published in the Code of Federal Regulations. And in the UK, since it left the EU post-Brexit, it has adopted an autonomous regime. And now the government, through Secretary of State or Treasury, has the power to issue sanctions, and those powers are specifically granted under what we call the Sanctions and Anti-Money Laundering Act of 2018. And so it's interesting also to analyze the UK sanctions regime, because although it is based on originally on the EU regime, it has adopted some different regime sanctions, and there are some differences between the UK now and the EU, which adds a complexity layer to the situation. And the authority that is responsible for the supervision and the enforcement of the sanctions regime is the Office of Financial Sanctions Implementation and His Majesty Revenue and Customs. So just a very small comment on this. As you can see, I have chosen 3 different jurisdictions, and just to make a point that when you have a complex situation which involves several jurisdictions, you have a multinational or a company that has branches or subsidiaries in several states around the world, it's very important to assess jurisdiction by jurisdiction and not to make a kind of admission that if it works in one jurisdiction, it will be accepted in another, because this is not the case. So something to bear in mind. Then just presentation on the type of sanctions that can be imposed. We are talking a lot about the financial sanctions, but there might be also some different other type of sanctions, such as diplomatic or any specific sanctions that are imposed based on the EU treaties, for example, arms embargoes or travel bans. Then could be also freezing of assets, or as we are going to see, economic sanctions, for instance, bans, investment bans, or import or export bans. And also, the EU is not the only authority that is imposing sanctions. There are also sanctions at the level of the UN. So this gives you a broad idea of what type of sanctions can be imposed. Then when it comes to, now we're diving into a bit more details with respect to the EU regime. So you will first need to determine what is the scope of application. So am I concerned by this regime, the sanctions EU regime? And actually the EU regime has a bit of extraterritorial effect. As you can see, it concerns any person that is a national of a member state, or a company that is incorporated under the laws of a member state, and that is acting either inside the EU or outside. So there is a proximity of citizenship or place of incorporation. But it also concerns any act of any persons or any entity, no matter where this entity is incorporated, and that is doing business in whole or in part within the EU. And of course, so this is quite a broad application of the EU. And there is also a small aspect if, of course, there is an intent to circumvent the regulation, then it's also taken into account. So this is for the EU scope of application. And then next slide, please. So within the UK, it's a bit similar to the EU in a sense that there is also this territorial reach. So it concerns any act within the territory of the UK. There is also proximity with the citizenship or the place of jurisdiction of a company. There's also provision with respect to the facilitation of transactions. So if a person or an entity intends to facilitate a transaction, this will amount to non-compliance with the sanctions regime. And with respect to the US, it's a little bit trickier because it also has the same type of application, meaning territorial and citizenship of place of incorporation. But there's also what we call the US nexus, which actually kind of broaden up the jurisdictional reach of the US. And there are several factors that can attract US jurisdiction, such as, for instance, the payment in dollars, or the place where your software or the IT infrastructure is situated. For instance, if it's in the US, it might attract the US reach. So just something to bear in mind for the US jurisdiction. Next slide, please. So then the second question is, once you determine if you are within the scope of the EU regime, you will need to also determine whether the entity you are dealing with is a concerned, as we call it, designated entity that is caught by the sanctions regime. And the approach of the EU and the UK is pretty similar here. So of course, the first entity are the ones that are listed in the regulation, and you will see that in the regulation there are a lot of schedules, and it will carefully list all the entities that are directly concerned by the regulation. So it's usually entities that are established in Russia, but not only those type of entities. It's also if you have any entity that is owned or controlled by an entity in Russia. So there is this idea of ownership or control. And a third layer is even broader than that. It's if an entity is acting on behalf or at the direction of, for instance, a Russian entity. So it's quite a broad analysis. So that has to be carefully determined on whether you are dealing or transacting with an entity that is considered as a designated entity. And in the UK, the approach is pretty similar. And now that post-Brexit, you will also need to consider that the EU incorporated subsidiaries are covered by the sanctions UK regime. In the US, I will not go into the detail, but they have the same principle of designated entity. There is a list that has been established by OFAC, and you will see on in this list the special, as they call it, specially designated nationals and blocked persons list that is publicly available and that you can also rely on. Next slide, please. I just talked about the notion of ownership and control. What exactly means ownership and control? And in that sense, there is a slight difference between the UK and the EU interpretation. So in the EU guidance, we will have the 50% for ownership. But for instance, for control, the EU issued a guidance where it stated several criteria to determine whether there is a control or not. For instance, whether an entity can appoint the board composition, or whether it has an influence on the decision making of another entity. So there is several criteria, and this is also very fact specific. And in the UK, it's pretty much the same mechanism of having an influence, or for instance, having voting rights in another entity. But there's also a second criteria, which is whether it is reasonable to expect that a designated person could ensure that the affairs of the entity are conducted in accordance with their wishes. So it's a reasonable expectations whether you are controlling the entity so that the other entity is conducting according to what you want it to do. And this is a quite subjective test, and there's not a lot of guidance on this. And so this has to be also assessed case by case. And in the US, it's also the same principle of ownership 50% and control as well. Next slide, please. So once you have determined who is concerned by the sanctions regime, I would like to give you just a very broad understanding of how the regulation regime works. So as a matter of principle, you start with the fact that your transaction is prohibited, and then you go on to see whether there are any exceptions or licenses / authorizations that can be granted by a competent authority. And it's important, I think, to specify that if there are any exceptions that are directly written in the text, that means that you don't need to apply for a license. And if you can apply for a license, you will need to, of course, to verify whether you have the grounds that are specifically also listed in the regulations that you can rely on to apply for a license. And if a license is granted by the competent authority, it is valid throughout the EU. So there is a bit of a passport mechanism here. And you can also have access to the competent authority per member state that is published in the EU website for specific questions on that. Then in the UK, there's also the mechanism of, it's the same approach of prohibition, exceptions, and licenses that are available. And the very big difference, I would say, with the EU regime is that in the UK, you also have the system of general licenses. And for that, general licenses are directly taken by the OFCE, and you don't need to apply for it. Actually, you cannot apply for it. It's a decision that is taken directly by the authority, and you can also consult them online. They're publicly available, and you will need to carefully analyze the terms of those general licenses because they're granted on specific conditions and for a duration, or sometimes they are unlimited. Bear in mind that in that case, you will still need to notify the OFCE if you want to rely on that general license, and you will need to record keeping of your activity. In the US, there are also the same type of general/specific licenses, and the OFAC can also exclude some transaction from licenses process. So just going then to the penalties is it's one thing that something is written, the other is who can impose penalties. And what's interesting to note is that at least at the EU level, the penalties are determined by member state. So there's no harmonization on that. And there is a proposal that has been made by the Commission to enable the Council and the Parliament to establish the minimum rules concerning the definition of criminal offenses and penalties, but it has not been adopted yet. So there is a kind of aim for harmonization, at least for penalties throughout the EU. As far as Luxembourg is concerned, for instance, the fines can have a range from, well, 2,050K to 5 million. And there's also a risk of imprisonment from 8 days to 5 years. And as a matter of fact, if you're doing some activities that are called by the sanctions regime, you will need to inform also the Ministry of Finance if you are executing any of those restrictive measures. And in the financial sector, the CSSF is, which is the control authority for the credit institutions, for instance, is also closely monitoring the implementation of the sanctions regime. Numa, would you like to add something on that, or?
Well, thank you for this like very complete and short summary of the situation. Basically, the idea is that even if I'm specifically talking about the AU, that we may be tempted to see that as a unique jurisdiction. I think your point is very clear and very relevant to this. It's very important, especially when you are outside AU, not to see AU as a unique jurisdiction, because even if you have a unified framework with this regulation, the application of the regulation especially give room and an authority to at the national level to make a final decision. If you take, for instance, France, if you have, and we will see that later, dual-use goods that you want to export, even if we're going to take the European regulation, you're also going to have to take into account the French regulation, and the DGA, the administration in charge of it, will have the final word on the granting or not of the license. So that's a point that you are very right to stress on, and I want to emphasize on it once again. It's not because AU has a unified regulation that the application is unified. There is a really country by country, as you mentioned, Luxembourg has its own. So that's something very important to keep in mind. Yeah.
Yes. So just small now outlook on the energy sector, and then I will dive into the financial sector. So it will not be exhaustive, but just to give you a flavor and idea of what the regulation have. So with respect to the energy, next slide, please. Thank you. So for instance, there is a prohibition on the financing to any entity that is operating in the energy sector in Russia. And there are two small exceptions. The one is to ensure that there is a critical energy supply in the EU. And another example is a prohibition on the exportation of any goods or technology that is used for in all refining or liquefaction of natural gas. And you have a specific list that is can be found in the Annex 5 of the regulation. And in that respect, for the export, you are also prohibited to provide any related technical or financial assistance. And for instance, for this prohibition, there is a possibility of prior authorization, provided that you rely on the grounds that are accepted and foreseen by the regulation. And usually those grounds are, for instance, if there is a significant impact on health and safety or there is an impact on the environment. And of course, the competent authority will have a discretionary power to grant such authorization. And for this provision also, you may have, there is a possibility of no prior authorization, provided that it's an emergency situation, but still you have an obligation to notify your competent authority within 5 days after the transaction took place. And so there are also other type of provisions that concern, for instance, import of steel and iron products, coal and other solid fossil fuels. This one has a limited time exception, and another provision that concerns crude oil products or petroleum products in relation to any purchase, import, or transfer of those products, with some limited exceptions as well. Then the next slide, please. So now I will go into the financial services. There's also a list of the different type of activities that are concerned here. So for instance, it is prohibited to grant any public financing for trade or investments in Russia. And under this prohibition, you have certain exceptions, provided that certain thresholds amount, timing, or purpose is satisfied. And you have also prohibitions, for instance, on dealing with transferable securities and money market instruments that have been issued after the 12th of April 2022. And here I wanted to highlight there is a UK particularity, because the UK considers not only dealing with those type of securities, but also whether you have reasonable cause to suspect that this dealing might be caught by the sanctions regime. So it's slightly broader than the text that is written in the EU regulations. And there's also a provision on granting new loans or credit with a maturity date of more than 30 days. And there are quite a few exceptions for that. For example, one of these exceptions might be emergency funding need to meet solvency and liquidity criteria for EU entities. And another example in the financial services sector is the prohibition to take any deposits that are above the thresholds of 100K. And you can also apply for an authorization here, provided you also rely on the specific grounds that are listed in the regulation. And examples of those grounds might be if you want to satisfy the basic needs of a person, or you have an extraordinary expenditure, or you need to, for example, pay with some reasonable professional fees or legal services, or humanitarian purpose. And for financial institutions, in any case, you will need to inform the national competent authority if the deposits are above 100K. There are also, of course, sanctions that concerns other financial services, such as providing of credit rating services or SWIFT and CSD services as well. And generally, there is also a general prohibition for any transaction with publicly controlled entities in Russia. So I just wanted also to highlight the provisions that are in relation to the provision of corporate services. So that might concern the provision of, for instance, trust management services that are prohibited with some exceptions as well, and some authorizations that may be granted on also on limited grounds. And there's also a prohibition to provide accounting or tax services to all Russian entities. Again, there are some exceptions. For instance, if you want to provide legal defense, and there's also an authorization that can be granted, but also only for some specific reasons. And those reasons could be, for instance, humanitarian purpose, or promotion of democracy in Russia. And with respect to legal services, it's also interesting to note that, for instance, in the US, certain legal services can be authorized. So you are asking a specific authorization to an authority to represent your client, provided that under certain specific conditions, if you want to be paid for your services. And in any case, the lawyer must be licensed to receive payment if you're acting for an entity that is on the list of a blocked person, for example. So that's for my part.
All right, thank you so much for this like very detailed but again summarized vision, because there is a lot of things, a lot of parameters to take into account in two very major sectors such as energy and finance. So in order to finish this this webinar, I wanted to have a small discussion about the dual use sector. What is dual use, first of all? Because that's something that may not that may look self-explanatory, but it's always good to repeat it. Basically, dual use goods that are items that can be used either for civilian or military purposes. Why is this very important for the space sector per se? Is that the space sector is intrinsically dual use. A rocket can be a missile. Technically, that's quite the same thing, just done the same direction, but that the same technical concept and the same technical application. So that's why, in order to export, import, and transfer this type of goods, you are under this very specific regime. But also, that's why this presentation is of course illustrated with space, but that can be applied to a different type of technology, such as, like, for instance, chemical tools, biological tools, like night vision goggles are like the icon of a dual use technology. You also have some of drones. You also have some pipes, tubes, aluminum things that can be qualified as dual use goods. So that's we are really on the crossroad of the civilian and the military regime. That's why we have this very specific export control and sanction regime applicable. The military is a little bit on the side, especially for the current context, since everything is basically blocked, except for a few very specific exemptions that need to be treated on a case-by-case basis only. So just a few words about what's going on with space, because Russia and the West and the West and the rest of the world are really generally historically deep into a space cooperation, especially since the end of the Cold War. You had Russian scientists in French Guiana, in Kourou. What's the situation right now? The event started in February, March. Now we are in September, beginning of October. What's the situation right now? So for the space industry, we don't have any more Russian presence in French Guiana. All the teams, the Russian teams, have been recalled from this Centre Spatial Guyanais, thus ending for now, or maybe for a long time, depending on the outcome of the geopolitical context. There's no formal cooperation anymore on this regard. Some missions are suspended, or we don't really know what's going on on the longer term, like ExoMars, even if ExoMars has a specific regime. We'll see that later. We also saw, especially regarding the launcher, since Russia was traditionally providing reliable and very technologically proven Soyuz. Now it's over for exportation. Thus, OneWeb, for instance, switched to SpaceX. There was some question regarding the ISS. We know now that Russia has the intention to stay on the ISS, and that apparently everything is going well. So this situation is stable for now. Regarding Galileo, now Ariane 6 maybe would be used, or Falcon maybe. So in the long story short, the space cooperation is actually weakened by the conflict on the larger scale, given the importance of Russia in this type of sector. Just a very specific point on the launches, since Soyuz was such a big part of the industry on an export side of the industry. Some alternatives are to be developed and found, but we see two rising tensions. One is about the real availability of launchers, since Russia does not provide launchers anymore to the export, at least to the West. And there is also rising tension on supply, since Russia is also providing resources and parts. We'll see also on the sanction regime that some resources are allowed to be exported, especially the fuel. Investment on the investment side. For now, the foreign investment control rule are quite stable. Of course, there is regulation both in EU and applicable in France that are blocking investment from Russia, but there is not a dramatic evolution since the beginning of the events. It's very important to notice that Russia has been disconnected, of course, from the Swiss system that make payments of international contract quite complicated. There's also a batch of measures that's apparently have been adopted in Russia. It's quite complicated to have confirmation of the actual enforcement of these measures, but apparently there is an equivalent of the European sanction in Russia. So that may also hit the IP, and also the nationalization of foreign investors' assets need to be, of course, confirmed more deeply. There is also, because the space sector is harmed by this situation, there is also strategic issues, like there is some concern about the satellites. Indeed, maybe possible jamming, like some people were talking about GPS, and you also have a potentiality of collateral damages. So that's why the space sector is quite under scrutiny on this. Supplies, as I was mentioning before, are quite tense, especially regarding some parts and some key elements that were done in Russia and some part also in Ukraine. But as I said earlier, Russia is supposed to stay on the ISS until at least 2028. So there is some stability in this ocean of uncertainty. But on the other side, regarding the use of Russian launchers, like some countries are a little bit stepping back, like for instance South Korea. So long story short, as I said before, high uncertainty and high risk regarding the space sector and the relation with Russian space industry. I wanted also to discuss a bit more about what's going on the EU sanction regime. I will not, of course, I will not read all the article that you are seeing here. The idea I wanted to tell you is that and as you saw, and thanks to the presentation of Katia, the regulation has been adopted in a very short period of time. There was a former regulation that back from in 2014. This has been updated quite on a rush since February. As you can see, there is a long list of additional text that has been consolidated quite. So that makes some weird text to analyze, because you have a lot of repetition. And you still have the general idea is that there is a strong principle of basically a ban. In practice, the situation is a little bit more complicated, since you also have some exemptions. So I wanted to just illustrate it with a few examples of articles. The article that you are seeing now is the basic regarding dual use. There is a prohibition on selling, supplying, transferring, exporting directly or indirectly dual-use goods and technology. So that's something that is the core principle. But if you have a deeper look, you see that some exemptions are possible, especially the intergovernmental cooperation in space programs. So you might, and I use the word might, be allowed to export space technology if you are within an intergovernmental cooperation in space program. So you see, you have the idea of the ban, and then you have the possible derogation. What is, that's the 4B. What is the exact application of this sentence? That's when you start negotiating with your national entity. If you are in EU, for example, you are in France or in Luxembourg, you are part of a company of an entity that are dealing with intergovernmental cooperation in space program. You may be willing to have some export. You have to discuss this point directly with your national authority, because that's going to be the one taking the decision based on this text. But the important point for you to have in mind is that even if there is a ban, there is this potential derogation in the text. Same question. Just passing it. Same question, for instance, regarding the fuel. We say that a lot of materials and parts are not authorized. Here you can see the principle: you cannot sell, supply, whatever, every goods and technology used in the space industry, and boom, you go directly to the potential derogation, and you have possibility to go through that, or some exemption are possible. It's the same for dual use goods that are close to the military list. Military list is basically a giant list of technologies that are so sensitive that they need to have an extra screening. That's the same here. You may have some exemption, especially for European space programs. So if you take, for instance, the presence of Russian people in French Guiana, it was an intergovernmental space program. It was a European space program also. So under this framework, from a very strictly legal point of view, it was possible to maintain it. Of course, after that, you have all the layer of politics, diplomacy, but from a strictly regulatory and legal point of view, you had some ways to benefit from a derogatory regime. So that's why it's very important to have this in mind. Same we were discussing earlier on the presentation, the fate of ExoMars. ExoMars has been has a dedicated regime in order for it to keep being alive. The problem is, and that the other side of the issue, you have the regulatory side of the issue, and then you have the diplomatic and political side of it. So that's two different issue, but the legal one is a little bit backed by this type of document. And you can go all over and all over. You have like a lot of strong principle regarding the public owning of entity that are owned by the Russian government. You can't have any transfer or export with them, except if you are in this idea of intergovernmental cooperation of space programs. Same idea also if you have dealing with entity owned or controlled by 50%, by the famous rules of the 50% threshold that has been explained by Katya. You can't, but if you have this involvement in a cooperation in space program, you might benefit from a derogatory regime. I just wanted to have a quick point on the Annex 7. So that the general construction of this regulation of the AU is you have like a traditional directive or regulation. You have the text of the articles, and then you have a lot of annexes, and that's where you see there is a common factor with export control regulation. Because basically what you do, especially for the space industry, but that's not topical for the space industry, you do that for a lot of different industries. You have your product or your good, and you qualify it vis-a-vis a list of technology and good that are concerned expressly by this regulation. So that's why you see in this very document that tells you that you can't forward, that you can transfer, sell, whatever, dual use technology and good to Russia, except with some derogatory regime. And then you have the annex that applies to the derogatory regime, meaning that, for instance, you might be able to transfer space qualified digital instrumentation, magnetic tape, blah, blah, blah. You can also maybe transfer a LIDAR system. You can you could transfer CIC systems. So that's also very important to have when you have this project, or when you have this contract, ongoing contract of transferring, of exporting space goods to Russia or vice versa. You need to see if the general regulation is already targeting your very specific piece of technology. If not, you try to the upper level, and you try to know where you are within the derogatory regime. If you are within a space program, go and see the national point of contact. It can be DGA if you're in France. It can be Bureau du double usage, especially if you're in France. You can go to Luxembourg or the Luxembourg agency, etc., etc. Regarding the US, a very, very quick topic, as Katya mentioned, we used to work with a lot of international partners, and of course, this attorney licensed in California can help us to this type of authorization. The US has quite a similar, as you saw, regime. The main idea and philosophy that we have from the bureau is that case-by-case review is the main line. basically the every type of dual use technology you want you want to transfer, you need to have a case-by-case review. And don't forget also the entity list, which is quite crucial regarding the business you may want to do. Then a few minutes about what is very important to have in mind, the legal and contract management, because the events happen so quickly and so abruptly that a lot of actors, especially in the space sector, but I'm talking about a more general aspect, but space sector was really topical on this issue. You had a lot of international relationship for a while, especially on the very highly technical, sensitive, strategic domain, and then all of a sudden there was a big turmoil, and some people went out, and you don't really know how to manage your relation with your partners. So what can you do? It's always good to first evaluate the level of involvement. Is your company, is your business, that sounds obvious, but that's, you know, a lot of companies, they didn't do that in the beginning. So it's very important to know, how are you dependent on this type of crisis? Do you have clients in Russia? Do you have involvement in Russia? That's something you need to assess and to evaluate quite precisely. It's also very important, and thanks to the people that are today connected to this webinar, it's also important to keep its firm monitoring about all the regulatory developments happening right now. It's very important to keep information updated about what's going on here. And then, if you were negotiating contract, if you have contracts happening right now, you need to start an audit, because all the contracts that are with Russia or Russian counterpart, they may be suspended, some may have been terminated, but in some cases, they are just suspended. So it's important for you to know what's going on and what is the situation, what may be the possible outcome in the near future. A few pieces of general information about how to see the situation from a contract side, especially regarding the space industry, but you may apply it to other type of industrial contracts indeed. First thing first, it's very important to maintain a dialogue. If you have Russian counterparts, even if the dialogue is, of course, very, very quick, very short, and cannot be like before, of course, it's very important to, especially if you have a pending contract, to keep the dialogue open. If you have, for instance, the steering committee that is on the contractual documents, try to have some sort of, like, for instance, a digital meeting and just asking what is the situation now, and you make a minute and said, okay, nothing changed, the contract is suspended, end of the discussion. So it's very important for you to keep a log, to keep the contract alive if the contract is still alive or just suspended. But you know that the relation that you have from a contract point of view, if it's not broken, if it's not like repealed, if the contract is not over, you can't have this suspended and without any dialogue. We need to keep at least the minimum dialogue with your co-contractor. Also, beware of delays. Now, when the crisis started during the winter, we were forecasting some delays especially in the production. There were indeed some delays. There were some shortages of some goods, but that's something that needs to be taken into account very, very quickly. Especially if you have, for instance, satellite projects in the next 2 years or 3 years. Be aware that there is a reconfiguration of the supply chain on a global scale. So you need to at least just, if you have even if it's long term, just ask a question to supplier. Given the current situation, what should I expect? Do you think you're going to have some delays? Open a dialogue if you didn't have done it yet. Regarding the licenses, of course, be careful. Be careful about the fact that, especially if you have export activities and if you have ongoing contracts with Russia, the general ban is the principle, but as you saw, you might have some derogation in the very specific circumstances. Be also careful about the financial conditions. Don't forget that Russia is disconnected from the SWIFT system, so that's another brick of complexity added. And excuse me. Once again, be careful with force majeure. Force majeure is not the Graal. Force majeure can be a tricky part. I think it's all clear for everyone. So just now need to say thank you for attending this webinar. And thank you, Katia, for agreeing to organize this with me. It was very nice, very nice first experience. Yes. on this very specific topic. Very specific topic. We hope that that it gave you some first level of information, some incentive to maybe know more if you have some concern with these specific topics. And feel free, of course, to reach us if you need any more specific legal services about this. As we mentioned, we can do auditing and special session for your needs, because as Katia mentioned at the beginning of the webinar, it's very important to have a case-by-case review. And even if we can provide general information, the most important thing is to know what's in your contracts or situation, and what is also the very specific case you are within the regulation. Katia, if you want to.
Yes, thanks a lot, Numa. It was a real pleasure to conduct this webinar. I think we covered quite complementary fields as well, and it gives you a rough and big idea of how the sanction regime works in 3 different jurisdictions. And I hope you found it informative. And as Numa said, if you have any questions in relation to either EU, French, Luxembourg, or US aspects, don't hesitate to reach out, and it will be our pleasure to reply to you.
All right. Thank you so much, everyone, and have a great day. See you soon.
Thank you. See you soon. Bye-bye.
Bye-bye.